The Supreme Court said the prison sentence Cheyenne Sharma received for a drug conviction did not violate her charter rights. In 2016, her lawyers argued for a conditional sentence, but the judge refused. An Ontario Superior Court overturned the decision, but Canada's top court has now upheld the initial ruling. Senator Kim Pate says it is a sad day for female Indigenous justice advocates.
I'm very disappointed in the majority decision. It feels like they've got their heads in the sand, and it's some nice academic arguments, but misses the totality of the inequality that exists, particularly for poor Indigenous women with past histories of abuse, and especially when they're single moms trying to survive abject poverty.
Adam Bond is a lawyer with the Native Women's Association of Canada. He says it is amazing the Supreme Court was unable to fully take into account the historic injustices against Indigenous women and why they end up in incarceration.
But the majority said that, interestingly, that Ms. Sharma should have adduced something more, some more evidence, perhaps expert evidence or statistical evidence to prove that the impugned provisions do cause this distinction on the basis of race.
Bond says Canada's top court has now basically thrown the issue back to Parliament and left it up to MPs to determine how conditional sentences are best applied to Indigenous women that find themselves on the wrong side of the law. Legislation is currently going through Parliament called Bill C-5 that would do away with mandatory minimum sentences.
It is very important not just that Parliament move forward with these Bill C-5 amendments, but they do a lot more. Parliament needs to act because the Gladue framework is in crisis. It's been damaged. It's not working. It was never intended to be, the one, kind of solution to the overrepresentation of Indigenous people. It was just one tool. Now it's been harmed, so we can be sure that the issues are going to get worse, that the overrepresentation is going to get worse.
But Pate and others in the Senate want to amend the proposed legislation so that conditional sentences can be more broadly applied and recognize historic injustices against Indigenous women. And she says, in a way, the defeat by the Supreme Court provides an opportunity.
We have not finished with Bill C-5 yet, and knowing that this is the message that the court is sending to us, that if we want to see something different, then we better act. And so let's act.
Fraser Needham, APTN National News, Ottawa.